Good afternoon, everybody. You're very welcome to this, the third in our series of webinars focusing on the impacts of COVID-19 on the built environment. We've had two very successful webinars so far. Hopefully you found them informative for those of you who joined them. First focusing on the impact on the residential sector and the second on the retail, hotel and leisure sector. Today we're looking at the implications of the current crisis for the construction sector, and I'm joined by two of my colleagues, Shane Dolan. Shane is a partner in our construction department, and Eoin is a senior associate in the construction department. And Owen's going to talk to us today about the impacts on the Irish planning system and economic development. And then Shane's going to be a slightly more immediate implications. And he's going to talk us through some of the relevant provisions in the RIAI form of building agreement. Each of the speakers will talk for about 10 or 12 minutes, and we'll hopefully have time at the end for 10 or 12 minutes of Q&A. So if you do have any questions for our speakers, do please insert them into the Q&A function in the front of the panel, and we'll try to get as many of those answered at the end as we can. So I'll hand you over to our first speaker now, Eoin Brady. Thank you.
Thanks very much, Jamie, and thank you. So like every sector of the economy, the planning system has been significantly impacted by the coronavirus crisis. So I'm just going to speak briefly about, how we're seeing that, how those impacts are working out through the system, and maybe just speculating about how there could be future impacts as well. So it's important to recognise, just in terms of the planning system, to put it in context, the planning system is bounded by law and by the Constitution. And at the core of the planning system in Ireland is the concept of third-party appeals. It really is a central thing, and it's been around really since the beginning of the planning code in the early 1960s. And central to that concept of third-party appeals is the ability of people to engage in the planning system. And that planning system is founded upon the planning register, which each planning authority and An Bord Pleanála must maintain. And that's contained in Section 7 of the Act. And that really is at the core of the Irish planning system, this concept of the planning register. And it basically provides for a paper-based system. Now, there is provision within the Planning Development Act for the use of IT, but it is founded primarily on that use of paper. So if you think then of the An Bord Pleanála offices on Arbitration Street in Dublin, you have a couple of floors there, but basically, the files, the appeals come in on the ground floor, either through the post or in the public office, and they're moved up to the first floor, where there's approximately 50 people normally working and doing various tasks with that paper as it moves around. So if you just think of the social distancing issues that have arisen with coronavirus, that has created issues for An Bord Pleanála in terms of how they can operate their own offices internally. And then obviously the issue of the public office, about the ability of people to come to the public office on Marlborough Street and inspect files. And that is not there at the moment, as we've seen. So I just wanted to maybe just give you some sense of why it is so important that the board and planning authorities be able to administer their files correctly. Because there is no latitude within the Planning Act essentially for any slippage. And I just want to refer to one case, which is Sweetman and An Bord Pleanála, which was a decision of Judge MacDonald back at the end of January, before this crisis really took hold. It was basically where An Bord Pleanála are obliged under the regulations to publish what's called a weekly list on the Wednesday following the previous week with a notice of all the appeals that have been made to the board during that time. And Peter Sweetman noticed that the appeal for this solar farm in County Cork was not included in the previous the week's list, and he took a judicial review of this, and he succeeded essentially and had the planning permission for the solar development quashed. And this, as I said, it was just a couple of weeks ago, and the judge in that case said that failure had serious consequences in that any member of the public, including the applicant, who happened to read the weekly list on the 28th of February 2018, would not have been aware that an appeal had taken place against the decision to grant permission for this extensive solar farm development, and this had serious implications for the right of public participation. So it is with an eye to this, this requirement for public participation that the government and the Department for Housing and Planning have approached the question of trying to maintain the integrity of the planning system during this crisis. So the solution that they've come up with is what's called the Section 151A order, which was contained within the emergency provisions in the Public Interest Act that came in a number of weeks ago. And it provides for a pause in relation to the relevant time periods in a range of legislation. And how that acts is that for the duration of the pause, the appropriate period, specified period, or other time limit referred to in that range of legislation is to be disregarded. So what that means in effect is that the pause period, whatever length that pause period is to be added on to whatever is the relevant time period applying to a particular step in the planning process. So basically, there's a range of legislation that said that this order affects. Primarily, of course, is the Planning and Development Act 2000, but there's also the Building Control Act 1990, the Derelict Sites Act 1990, the Urban Regeneration and Housing Act 2015, which deals with the vacant site levies, and then there's the Planning and Development Housing and Residential Tenancies Act 2016, which deals with the strategic housing development provisions. So basically, the first Section 151 order was made on back on the 29th of March, and it applied a 23-day extension of public participation periods up until actually today, the 20th of April. But just last Friday, the government decided that they were going to extend that order by a further 19 days, which would bring it up to the 9th of May. Now, assuming that the order does expire on the 9th of May, and of course that is an open question, any application lodged before the 21st of February 2020, the planning authority concerned can proceed to make a decision on that. And the reason is that the 5-week period for public consultation will have expired, and there's no legal impediment then for the authority to go ahead and make that decision. For applications that are lodged after the 21st of February 2020, a decision can now not be made until after the 9th of May 2020. And again, that's for that 5-week period of the public participation. And in cases where an application is lodged after the 29th of March, which is during the period of the order, a decision can now not be made until the earliest of the 15th of June of this year. So you can see that is a fairly significant issue. There's also issues arising from this in respect of how the courts deal with planning related matters. And as you're aware, a lot of planning, particularly more significant planning matters, end up in the courts. And there's already a backlog ever before there was the COVID-19 crisis. So one of the significant things is that the Section 151A order applies to Section 50 of the Planning and Development Act, which is the 8-week time period for taking judicial reviews. So that's obviously going to create issues for projects, and those limited a range of projects that will come through the system during the suspension order under Section 151, because the 8-week period won't have begun to run until that order has expired. Now, currently, as it stands, all High Court planning matters are generally adjourned, as with all other matters generally, and non-emergency matters in the High Court. But the planning issues have been identified by the Chief Justice to the Planning Bar Association as being eminently suitable to be tried remotely using IT systems. Now, the first actual mock trial of a planning matter took place just last Friday. It basically was unsuccessful. There was some issues with the IT systems, and that the different types and formats of documents weren't downloading correctly, but hopefully they can identify those issues and step through them. There was actually a successful trial on the same day in the Court of Appeal, you know, that worked out well. And Mason, Hayes and Curran are actually involved in trying to progress these remote trials and experimenting with different technology platforms, etc. Actually, the first Court of Appeal case that was due to run remotely was due to happen tomorrow. It was the case of Spencer Dock Development in Dublin City Council in relation to a tower block just on the quays, the height of a tower block. That is now actually not progressing because of some technical difficulties that are being experienced. Just to kind of round up, I suppose, and looking ahead as to where we see things going, and having discussed it with different practitioners, I think it's fair to say that that the measures taken are prudent and fair, and they have had the effect really of stabilising and maintaining the integrity of the planning system. From that point of view, they're absolutely to be welcomed. But there are particular issues and concerns that may be arising. one issue is around the staff resourcing in planning departments. We're seeing some level of redeployment of staff from planning departments into other departments that are being seen as sort of more critical in the crisis. The other issue is then, if the social distancing, as I said, is to continue to any degree, to what extent then the question must be posed as to whether normal services can be resumed in terms of the public opening of planning offices. If these sort of impacts were to occur, there can be no doubt that we will see impacts in terms of maybe projects and that are going to be impacted by this, particularly around strategic housing and other strategic infrastructure development. So I'm thinking that there could be impacts in due course on the achievement of rebuilding Ireland targets and our renewable energy targets. So it's something that we will be watching very, very closely. Again, as I said, the courts are trying to make really valiant efforts to try and achieve a workable solution in terms of remote trials. I know that the judge in charge of Judge MacDonald in charge of the strategic infrastructure list in the High Court is really pushing this very hard at the moment to try and get a solution. But there are issues even around that in terms of the additional administrative burden on legal practices, etc., in terms of trying to establish remote trial facilities and all of that, and then the cost of who bears the additional costs that are involved with that. Looking to the longer term, there's going to be uncertainty as regards how this is going to play out. Say, looking at issues such as the calculation of development contributions under planning permissions, CPO time limits. So the question is whether these limits would apply to CPO processes that are running contemporaneously with planning processes. And there's always the potential that there could be legal challenges down the road in terms of issues that are arising in terms of this. So I suppose in a nutshell, I just have to say, look, it's a real time of uncertainty. We're continuing to watch the process closely and see what developments are taking place. So with that, I'll just hand you over to Shane, who's going to just focus in more on some of the concrete construction issues that are arising.
Thank you very much, Eoin. You're all very welcome. My name is Shane Dolan. I'm a partner in Mason Hayes & Curran's construction practice. And so the purpose of my talk today is to bring you through some of the clauses, the primary clauses in the RIAI building contract. And what I mean by primary and relevant are the clauses that are relevant to the shutdown of sites across the country for non-essential construction works. And then after that, I'm going to focus on, I suppose, the standard provisions. Just to note, I'm obviously aware that in a lot of projects and contracts that they're obviously subject to fairly heavily amended terms at times. But as I said, I'll focus on the standard terms. Where they go outside that, they'll obviously be subject to a fairly careful legal analysis in due course, no doubt. And then I'm going to finish up on just, I suppose, bring you through a couple of the things that I'm seeing in the market, which I hope might be informative to you. So perhaps just to kind of put a bit of context around what's been happening, bring folks up to date. In, I suppose, early March to up until the 27th of March, we were obviously, there were relatively, regular announcements issued by government at various stages. But obviously from the construction perspective and the ones that were relevant in terms of progress on sites was obviously the social distancing requirement. And obviously up to the 27th of March, contractors and employers alike were very focused on, I suppose, ensuring that they were able to comply with those social distancing. And obviously there was lots of press and media reports around the difficulties that they were encountering around that. But obviously since the 27th of March, things changed significantly. The government, most people remember on the Friday evening, they issued a directive essentially shutting down construction sites all across the country that were deemed to be non-essential services. So over the course of that weekend and I suppose weeks even up to date, obviously contractors and employers have turned their focus towards what the contract says in terms of both the contractor's entitlements and obviously the employer's entitlements. And obviously in recent weeks, things have even changed further with the introductions of new regulations. So I'll come on to those in a few minutes. So I suppose maybe just to deal with the actual, the two clauses. So clause 30, which deals with delay and extension of time. So there's actually three limbs to that clause. The first limb is that where the architect is of the opinion that the works are delayed as a result of force majeure, and then the contractor is required to give immediate notice. And then the architect has a corresponding obligation as soon as possible after that to make a fair and reasonable determination for an extension to the completion of the works. So what that actually means in practice is that the date for completion is going to be kicked out for a period of time during which the works are actually stopped, and the contractor is going to be released from his liability to pay liquidated damages. And that can have, I suppose, clause 30 is interesting, is actually equally interesting in what it doesn't say. So it doesn't say, for example, that the contractor has any entitlement to additional cost. And it's a feature that I've noticed in a lot of claim correspondence that have come across my desk in the last few weeks, is there seems to be a kind of a slight misunderstanding at times that clause 30 gives rise to additional costs. It certainly doesn't. Obviously that situation may well differ if bespoke terms say that, but certainly the standard terms don't. There's also a requirement in the standard terms for the contractor to make or to issue immediate notice of the entitlement. Now, obviously the thing that's missing from the clause is that it doesn't say that there's a consequence for failing to issue that immediate notice. So it doesn't say that the claim is time barred. So no doubt that'll be something that'll raise its head when disputes arise. And lastly, it doesn't say, doesn't provide any definition for what force majeure actually means. So unlike a lot of bespoke contracts, those that are heavily amended, there's absolutely no guidance in the contract as to what force majeure actually means. And there's obviously lots of case law around it, but ultimately, if a dispute ever goes into a formal dispute process, whether it's arbitration, adjudication, courts, anyone adjudicating a claim is going to have to look at the factual context and decide whether it was the party's intentions from all of the facts, be it the terms, possibly even the negotiations, whether the facts just highlight a party's intention that COVID-19 and stoppages arising from it would actually constitute a force majeure event. And for those interested in looking at a little bit of case law after this, there's a good case, a Supreme Court judgment from 2017, the Law Society of Ireland versus the Motor Insurance Bureau of Ireland, which is quite instructive around all of that. I suppose the second case or second clause I'm going to bring you to is clause 4, and that deals with, it's effectively the clause that facilitates additional money being paid to the contractor, and it is for variations arising from legislative enactments. So clause 4 requires that if the cost of performance of the contract is increased as a result of any legislative enactment, rule or order, or by the exercise of government of powers vested in it or otherwise, then the amount of that increase can be certified by the architect and added to the contract sum. So perhaps to put that into context in terms of the chronology that I mentioned earlier. So between the 27th, up until the 27th of March, we had these sort of social distancing type guidelines issued at government level. Between the 27th of March and the 8th of April, we had what were effectively government directives, but for all intents and purposes, they formed effectively guidelines. And then from the 8th of April up until, I think it brings us up until the 5th of May, we've had two sets of regulations that have, I suppose, underpinned the initial government directive. So as such, we really only have regulations in place to cover this stoppage from the 8th of April. So you can see lots of disputes potentially arising from all of this, and in particular deciding whether this clause 4, how it operates. So in terms of like, you know, for claims that arise prior to 8th of April, is clause 4 effective, and is it triggered? I mean, are those government guidelines and directives, do they fall within the definition of legislative enactment, rule or order, or exercise of government power? So there'll be lots of discussion, no doubt, about that. There'll be lots of discussion around what the nature of claims, what kinds of claims are actually recoverable under that clause, what the quantum of those claims are going to be. And I suspect as well, obviously, how those claims are evidenced. And none of those are going to be very easy questions to resolve. Then turning towards the approaches and the things that I'm seeing in the market. Obviously, since the site shut down on the 27th of March, and actually, to be fair, before the 27th of March, we obviously saw a pattern of contractors issuing claim letters. In some cases, they were quite vague in terms of the nature of the claim and substance and so on. And they're really just, I suppose, perhaps issued to mark employers' cards. Since the 27th of March, there's obviously been, I think we're all aware of the engagement in terms of CIF and advice from them. But there's obviously been a whole range of contractor type correspondence issued. And obviously developers and contractors, I suppose their approaches to those types of claim letters and responses obviously vary significantly at times, depending on third-party agreements, like is there an agreement for lease in the background? Is there, what do the funding arrangements look like? How complicated are those? So there's lots of kind of external factors, if you like, that dictate how parties respond to those claims. But one thing I've certainly seen, certainly in the last 2-3 weeks, is a kind of a pattern whereby employers, even if they have, in certain cases I've seen it, employers, even where they have very strong, very robust contractual terms, and they could potentially have, taken a hardline position, they've tended to steer clear of that at times. And there seems to be a much more collaborative and kind of constructive engagement between employers and contractors, or at least that's certainly been my experience. So what I've seen is employers really kind of trying to get stuck into the detail around what the contractor is doing on site. So as soon as the 27th of March directive issued, employers wanted to know what steps the contractor had taken to secure the site and make everything safe on it. They wanted to know things like, in terms of security, I saw certain office developments perhaps had 24-hour security on site. Others had CCTV. Employers were, asking perhaps, is there a possibility of remotely accessing that CCTV? If so, we'd obviously like to see that. So would our technical advisors. So they'd like effectively visibility on the site, visibility on the steps that the contractor is taking to mitigate the effect of the stoppage on both time and on costs. And for example, in terms of like the effect on program and mitigation steps, one of the things I've seen employers do is obviously make it very clear to contractors that, look, while we appreciate you've been directed to stop works on site, we do still expect that any of the works that can be performed off-site should still continue. So insofar as that people can work from home to develop design, to order materials, or whatever it happens to be, they expect that to continue. Just because there's a physical stop on site, the rest, anything that can continue really should continue. So there's lots of different things. So and ultimately what they've tried to do, as I said, is to get visibility on time and cost. In terms of cost, they look at, they try to see, they effectively want real-time information. They want to see what the contractor has incurred to date, and they obviously want to see what the contractor foresees having to incur at a future date, obviously so that there can be some level of engagement. And there's a whole process around that, and the letters that I've seen are actually quite detailed around that point. So maybe just to finish up on perhaps a couple of takeaways. Obviously, contractors need to be quite clear, I think, in terms of explaining and articulating what their claims actually are and which clauses are actually relevant. As I said, I've seen a number of claim correspondence, and it's actually quite difficult to decipher what the contractor actually is claiming for, and in particular, what clauses he's relying upon. In terms of employers and developers, I think input early on in terms of, with the legal, technical, and obviously the insurance advisors is kind of critical to kind of dealing with the claims that are undoubtedly going to come out of all of this, but also in terms of getting the information that the employer actually needs to kind of mitigate and to put a clear mitigation around the effect that the work stoppage is going to have on costs and on program. I'll finish up on that. If you have any questions, Jamie, happy to see those.
Shane, Eoin, thanks very much. That was very informative. It was interesting to see in particular, I suppose, the interplay between the planning phase in terms of actually planning through the planning process that Eoin's dealing with, and then Shane, where the sites are coming out of the ground and the different issues, albeit stemming from the same issue. We have a fantastic number of questions, some exceptionally detailed, some very, very hard ones to answer, which it's great to see that coming from your colleagues in the construction department, so we'll keep an eye on some of those. I suppose in fairness to the guys, while we'll try to give you a broad stroke or broad brush response to a lot of the questions, this is not legal advice, and please do link in with the guys in fairness directly afterwards if you'd like to chat through any more of your questions. So I think maybe the first one or two are for yourself, Eoin. Does the extension of time apply to submissions to address further information requests from the council?
Well, yes. As I said earlier, basically any time limit that's specified in the Act basically is extended. So if the further information request is under particular provision that where it gives a certain amount of time, as it would generally be the case, then that is extended as well. And the other issue then is around the public participation element in that, because there's obviously then if we'll say if you've got an appropriate assessment or an EIA facility there as well, that needs to be considered in terms of public participation on that. Okay, and I think probably very linked to your answer there, Eoin. If a planning is granted, presumably a decision, does the 4-week appeal period still apply, or is that extended? So yeah, exactly. So basically that is extended as well. So time will not start to run until the order comes to effect. So it's basically, if anybody's unsure, you can just go back to the Act and see what is specified in the Act. So as I said at the outset, it's any period within the Act is extended. So there's no, and that's probably what I was saying, that it's very much a broad brush approach in terms of this Order 151A. So its effect is sort of absolute across the planning code. Okay, thanks. Maybe another one, Eoin, for yourself, if you want. The position in relation to the validation of a planning application once lodged. Do you know if applications are being validated or just being accepted? Yes, the planning departments are continuing to operate, and they're continuing to accept and deal with any applications that are lodged with them. So there's no issue with that. So if you look at Bord Pleanála, their offices are open from 9 o'clock to 12 every day for the receipt of applications. Their staff are continuing to deal with them in the normal manner. So there's no issue there around the receipt or the validation of planning applications. And it is obviously advisable, if you have a planning application ready to go, to get it in. And at least it's in the system and logged, even though there will be consequential delays in actually the planning authority determining that application. Okay. And let's compliment in there on my shirt. Thank you, Eoin.
Owen, will the vacant site levy be payable during the shutdown? I suppose if it's been determined that you have to pay it, presumably it's still payable, but is the window extended for payments?
Yeah, so like that is a good question. The time limit in terms of a demand letter is specified in the legislation. So it is extended, in my understanding. Myself and Shane were actually dealing with a vacant site appeal recently, just before the order came in. You know, and like the issue is, I suppose, is about actually the planning authorities being able to facilitate even payment, which is an issue, because in that case, we needed to physically file the money with for the lodging an appeal with the board. There was no facility to do so electronically. So those are kind of issues you're seeing as well in terms of that. And one of the issues, I suppose, as well, in terms of vacant site will be market value. You know, there could be issues there around the fact that in terms of the economic impacts that we're seeing, do vacant sites still hold the market value that was there? And that's obviously going to be an issue for the forthcoming year, 2021, when determinations are made in terms of vacant sites and things like that, you know.
Thanks, Owen. I think Shane's just getting away a little bit light there. Shane, you mentioned employer visibility. So what practical steps are you talking about in terms of employers getting visibility on contractors' costs during the stoppage?
Yeah, so I mean, you're talking about just getting real-time information in terms of costs that have been incurred. So you're talking about asking the right questions. So when claims are coming in, that you're responding to get the right detail later on to defend the claim. So, and not only to defend a claim, but just to actually, for an architect to actually properly administer the contract, really needs to be asking the question. So obviously it depends completely on the nature of the claim, and a lot of the time it will be the architect and the PM that'll specifically advise around what types of documentation they'll expect to see. But in terms then of even costs going forward, what you really want to be focusing in on is, and if you can, is to kind of, you know, see if you can get an agreement to effectively look at the costs that are going to be incurred effectively on an open book basis. And if you can agree that where costs are to be accrued, where it's possible that the employer might be asked written consent before those are incurred, obviously without prejudice to the terms of the contract, yada yada yada. But yeah, you want visibility both behind and in front.
Okay, thanks, Shane. There's a couple of questions here, Shane. I'll try to link them. They're all to do with insurance. So I suppose to the extent that you can comment on this, employers asking questions in relation to maintenance of contractors' insurances. What questions should employers be asking? And what if there's an owner-controlled insurance program?
Okay, obviously, if the contractor is maintaining the insurances, you're talking about contractors' all risks, public liability, employer's liability. What you really want is, I suppose, confirmation from the contractor that all of those insurances are being maintained. You want reasonable evidence of that, if you can get that. Obviously, a broker's letter is what I typically expect to see. You'd want the contractor to tell, I suppose you might want to inform the contractor that if the situation changes, to obviously let the architect or the employer know. In terms of an owner-controlled insurance program, I've seen it a couple of times in the last few weeks, where obviously the employer is maintaining the policy, and what they've done is they've effectively, and this has all obviously been on the advice of the client's insurance advisor, but you typically explain to the contractor that there's a certain obligation under the policy that during any cessation of works on the site. So in one policy, I think it was, if the works are stopped for more than 28 days, you have to do this, this, and this. So there might be requirements, for example, for the contractor to make sure, or sorry, for the insureds to make sure that the site is properly secured, that there's, you know, reasonable steps have been taken to make sure that it's monitored and inspected, and that there's no kind of, that any risks are, you know, in terms of physical damage are mitigated. So they're the types of issues that an insured might have to address during this period. And obviously the contractor having control of the site, so to speak, is obviously key in that process.
Okay, thanks, Shane. Is there an equivalent of an EOT for force majeure under the public works contract?
I don't, not that I don't believe so. I think the PwC contract, there's no entitlement to, I don't believe there's an equivalent of force majeure under the PwC. I think that up until when the regulations issued on the 8th of April, and then subsequently there was a note issued last week by the Office of Government Procurement. Up until those two things happened, there was no contractor entitlement, I believe, under the PwC. Obviously, when when the regulations issued there was a change of laws clause that was triggered. That did give rise to an extension of time from the 8th of April, I expect, onwards. In terms of additional money, I think the situation was that if a certain optional clause was included within the contract, then there was some level of recovery under that. But obviously, I think the contractor's position has improved quite a bit since then, even as a result of that that Office of Government Procurement note that issued last week. I think it's 14th of April. And that note, I think it actually backdated a contractor's entitlement to an extension of time from the 28th of March. And in terms of additional money, it provided for an ex gratia payment to contractors. So I think it's a one-off payment that contractors are going to get. And I believe it's a kind of there's expected to be a level of engagement with contractors. That payment will be quantified against a level of the prelims in the pricing document, and it will be agreed effectively in a kind of, that's what I assume, letters between the parties. But obviously, it's without I suppose it's without any admission of liability on the employer's part.
Thanks, Shane. Eoin, you touched on the implications for payment of vacant site levies. Do the same considerations apply to development contributions and timelines under planning permissions generally for work to be done?
Yeah, like that is an issue. The development contributions are generally, you know, specified in the planning permission. So it's not actually, you know, each will be sort of bespoke to each permission. So it's an area that is not clear at the moment, as far as I can see, in terms of how the development contributions could be impacted in terms of the level of such contributions. So yeah, it's something that has been identified that needs to be clarified. So I'm sure that I'm sure that planning authorities will you know, be reasonable, hopefully, in terms of how they approach this issue with developers in due course.
Okay, thanks. And then maybe 2 or 3 questions, Eoin, rolled into one. How are appeals to the board in terms of appeals by the applicant? Can appeals be submitted online? And are the board actually making and issuing decisions at the moment?
Yes, so appeals can be submitted online. So there is provision for that in the Act, and luckily that was there. But the thing is that basically, once it is received, the board will proceed to deal with it. But the issue is, again, that the public participation in that appeal can't take place for the duration of the suspension. So as I've outlined earlier, in terms of the timelines that are there, it'll all depend on when that appeal was made, and then in terms of calculating the amount of time at the other side of it. So look, the board is continuing to work and function as best it can, but the key thing, I suppose, is that that the facility for public inspection of files and submissions is no longer there for the duration of this, and that then will have the implication of slowing the process down. I think if there's any takeaway in terms of what this Section 151 order is going to do, is it's going to slow the planning system down quite significantly.
Okay, thanks. Okay, guys, I see we have 25 unanswered questions. It's conscious of time. We might just take 2 more questions, and we do have everyone's questions. And if you want to follow up with us, or the guys can link back in with anybody whose question hasn't been answered, we can do that. But Shane, have you seen recently, I suppose over the last couple of weeks, employers issuing formal notices of suspension to contractors?
Yes, I've seen it in, well, relatively limited scenarios, and I suppose the one particular scenario I've seen it in is a scenario where the contract had very specific drafting around it, and there was a kind of a whole. It wasn't even just it wasn't the clause itself was actually, it was a very robust provision, but it was actually external factors that dictated the issue of the notice rather than the employer in that case requiring it. But no, for the most part, employers certainly haven't been issuing notices to suspend works. It's maybe 5-10% of the ones that I've seen. Okay,
thanks, Shane. I appreciate you're talking about the standard form contract now, Shane, but do you know if arbitration is compulsory under the contract and whether that can be fast-tracked?
Whether arbitration is compulsory. There is an arbitration provision in the contract. I've seen before on probably 2-3 occasions, it's a good few years back, where my client and other parties agreed to fast track it, so to set aside any kind of precursors to arbitration. Of course, anything can be done by way of agreement, but it is compulsory under the current form. I've seen parties agree to waive their entitlements to arbitrate, to go to court for slightly different reasons than you would have thought. I probably shouldn't go into that any further. Yes, parties can agree to fast track it, they can agree to waive it in some way.
Thanks. Then maybe I'm not being screamed at to wrap this up, so I might take 1 or 2 more questions then, Eoin, if that's all right with you. The board recently granted permission for a CPO, and I know you touched on this on one of your slides actually. Will there be an extension of time for the acquiring authority to issue a notice to treat, or is that one of the gaps you mentioned earlier?
That is one of the gaps that one of the areas that is obviously dependent on the process that the CPO process, because there's different legislative, so you're thinking of the Housing Act 1966 and like that. The CPO process was not specifically dealt with in these range of legislation that I've outlined, and that's one thing that the practitioners are identifying is of concern. Now, in terms of on board Planal as oral hearings and all of that, in terms of CPO process, they are suspended. They're not taking place. But I suppose the question is what about in terms of where there has been an order and you're talking about a notice to treat. My own view is that is unaffected, because I don't see where the legislative basis for it is. So, but it definitely is an issue, because obviously, the general uncertainty out there about all sorts of statutory processes and everything in the current crisis. So it's one thing, as I said, that CPOs are definitely something that there is a concern around about, in terms of getting some clarity.
Okay, thank you. And then maybe it's the last question here. If you have your dates in front of you handy on, to check it. If a planning application was lodged on the 20th of March, can the council give notification of the decision to grant on 20th of May?
20th of March. So the thing is that it was within the 5-week period then before the 29th. So it was 9 days before the coming into effect of the order. So what you have to do there is to subtract your 5 weeks, your 9 days from the 5 weeks, and you then got that balance. Then you add that balance back on then to assuming that the order expires on the 9th of May, then that will, whatever date that is then is your new date that you have to go at. So there's actually a handy link on the Department of Housing. They have a FAQ which gives examples of all different dates, and you can just have a look at that and see, and you'll be able to see how that would affect each individual application in those terms.
Okay, thanks. And a final question then for Shane, I think. Shane, perhaps without going into the question which has come up about 15 times as to whether COVID-19 equals force majeure, do you think that can a force majeure clause be invoked more than once during the life of a project? Maybe if you take that question rather than focusing specifically on COVID-19.
Yeah, I haven't thought about it. Can it be?
I suppose the thinking here is that
waves, the various waves.
Correct.
And I wouldn't have seen what couldn't. I don't see any. There's no bar. Certainly no bar as to. There's certainly nothing in clause 30 that says force majeure can only happen once, and any particular force majeure can only be allowed on a one-off occasion. There's no wording to that effect. So without thinking about it further, my initial sense is it shouldn't be an issue.
Okay, well, listen, Shane, thank you very much. That was very interesting. I am extremely conscious that we didn't get to all of the questions there today, but Eoin, Shane, myself and the team will go through them, and we will link in with anybody who wants to take things further if that might be of use. Our events team will be shortly circulating a link to this webinar and the slides, and there will be an opportunity to fill in any comments you might have on a survey, both on the seminar itself and then anything you might want the team at Mason Hayes and Curran to cover over the coming days and weeks. But in the meantime, Eoin, Shane, thanks very much, and thanks to all of you for logging in.
Thanks, sir.
Thank you.
Thank you.
Thanks, everyone.
Thank you.